Well, hey, thanks for joining us this morning. This is Anthony Parent of IRS Medic, and we've had some, the more oral argument is coming up on Tuesday, and there is a lot of information out there going on about it. We're seeing opposing sides claim what this is, and right now I'm just going to start playing a video of an interview on CNBC, and it's actually a showdown between two different sides here. We have the Tax Foundation speaking in favor, the Tax Foundation speaking in favor of the transition tax. And we have in this situation and Senator Breaux, a retired senator, is against it, a Democrat, he's against it. And so, Dan Bunn of the Tax Foundation says a lot of things during this. We're just going to play this video with the captions here. We're not able to get the audio over here right now, and I'm just trying to mute it myself. So joining me this morning is John Richardson. Good morning, John, wherever you are coming from parts unknown. And also Keith Redmond as we discuss this video that we're seeing. So we're playing it in the background. And John, you actually had some tweets going on, and you had some commentary on this. And I watched the video, and I was incredibly offended. And it was really the Tax Foundation. It's really alarming that the Tax Foundation would come out with so much sort of and I heard things that weren't exactly true. So, John, where should we start with this as we're playing this in the background? What would you say was the first thing that you encountered that didn't seem quite right?
The whole thing. The characterization of it. Let's start here. Let me tell you why. Okay, why I'm really obviously interested, but extremely concerned about this. And the reason is that the issue is so incredibly complicated that it has opened the door to all kinds of incredible mischaracterizations of what's going on here. Okay. And I put up a tweet, sort of a tweet number 12 this morning, to my series. And I'd like to start here, okay, because here's what my concern is. More is not about a wealth tax. It's not about deferred income. It's not about multinationals. This case is about a current tax on retroactively created income attributed to an individual that the individual never received and now is being forced to pay tax on. That's what this case is really about, okay? And the tax academics are in absolute overdrive trying to obscure what this case is about. The tax academics are basically in overdrive trying.
Oh, it looks like we lost John there for a minute, and then we'll get over to his tweet. He'll pop on right now shortly.
He's coming from parts unknown. Code. Okay. And I would say right away, okay, that in fact, the distinguishing feature here is that this is about retroactively created income, okay? It in no way interferes with, the things they're talking about, partnership income, et cetera. The difference is very, very simple. Yeah. In the case of partnership income and that sort of stuff, we're dealing with events in real time. This is not real time, okay? This is a retroactively created income. Now, what's fascinating here, and I want to develop this point in our discussion today, is here's how they're trying to get around this. They're trying to claim that this is actually just deferred income.
Yeah,
okay?
that's yeah.
By claiming that it's deferred income, what they're really doing is trying to gloss over the issue of retroactivity. That's what they're really trying to do. There is no such thing as deferred income. And, you go back to the early years in the Kennedy administration, 61, 62, which I've done researching this, okay? And you see what was really going on. And what was going on was a very, very clear and deliberate decision to not include active income in the sum part F regime, to not include it. That doesn't mean it's deferred, okay? When they say deferred, what they mean is that when a distribution is made in real time, then it's taxed. Of course it's taxed in real time, okay? But by their definition of deferred, and I invite you to stop and think about this for a minute, Anthony, by their definition of deferred, what this really means, what they're really saying, the fundamental assumption of that statement is that any income anywhere in the world or anything at all is just waiting to be taxed by the United States when they decide to say, oh, it's deferred income. Okay?
It's deferred.
They
right?
could define anything they want as deferred income
right?
based on this. The simple fact of the matter is here. The simple fact is that this was not income until they retroactively created it as part of the TCJA. Okay?
That's right.
And that's what needs to be the focus of this, not all this other malarkey.
And that's, the confusion, and this is where, it's intentionally confusing. And that's where, I stopped it right here on the screenshot where Senator Breaux says, look, they never got any money. They never got any money, and you're taxing them retroactively. And we have the tax foundation saying, well, this is fine. And if we don't allow this, and this is sort of the problem, is like that, and this is sort of the argument that I kind of heard is like, well, hey, look, the rest of the tax code is probably unconstitutional. So what's the problem with this one? Hey, look, everything else we're doing is incredibly terrible. If we get rid of this terrible one, well, now there's a logical argument to get rid of everything else that's terrible. Not the strongest defense to me. And so that's really the point. The Moors never got money. And they may never get that money because it's not their money. It belongs to a corporation in which they're a shareholder, but it's not their money. If they took that money, guess what that would be? That would be embezzlement. They would go to prison for taking things that don't belong to them. But yet they're being taxed on something that doesn't belong to them retroactively. So it can't get any possibly worse than this. So, John, we can head over to your tweets that you have here. This was your last one you just sent over here. You want to start with you want to start here instead? On this page is instead your 10 that you had.
I'm having trouble. I'm on a small tablet, so I'm having trouble seeing. You mean start with tweet number 1?
Tweet number 1, yeah. So the earnings accumulated
go
before
tweet number 1, sure.
Yep, yeah.
Now we can start
yeah. So this is the earnings accumulated before 2017 by controlled foreign corporations were not deferred. They were earnings of a non-U.S. corporation that were not taxable by the U.S. as per U.S. tax law. There was never any obligation to bring those earnings into the U.S. tax system. The Tax Cuts and Jobs Act created both new income and a new tax. And it's not even, and I would even say those earnings belong to a corporation that aren't in the U.S. They're not part of the U.S. tax base. It's not. And retroactively.
Well, that's exactly right. And Anthony, I would add to that, okay? I mean, part of what's so offensive about this, including this video, is the Moors are individuals. This litigation is taking place in the context of a plaintiff who's an individual. The other thing these people are trying to do is completely ignore the fact that these are individuals. And as part of that, I mean, there's far more Americans abroad impacted by this than the total number of multinationals or anybody in the United States. There's absolutely no suggestion, no guarantee. In fact, I think not even a reasonable possibility in the case of individuals with CFCs that this money would ever be coming back to the United States.
Right. It was right. That's not. Corporations don't exist in this world to send money to the United States. I know.
Well,
that's actually a hard concept. It's actually a hard concept.
It's a very hard concept for the U.S. tax community, a very hard concept, okay? But it is absolutely true. So, so that's the first thing. There's no obligation. And by the way, the absolute 100% proof positive of this is that in the early 2000s, recognizing there was no obligation to ever bring this money back, the U.S. government offered a 5% tax if they bring it back. Okay? I mean, this business about this is deferred, it was an absolute fantasy. It's a fabrication. Okay?
Exactly. This is not deferred income. That's the lie. First lie right there. It is not deferred income. It's invented.
Exactly. And I want to emphasize the impact.
Cannot exist.
I want to emphasize, Anthony, why that lie is significant. It's significant because if it was always income, deferred income, then how can it be retroactive, right? It's a way of bypassing the issue of retroactivity.
Yeah.
You see what I'm saying?
Right. That's not going to stop it. Logic isn't going to stop these monsters. That's for sure. Number two, the suggestion that Control 4 corporations were, prior to 2007-2, pass-through entities is wrong. Subpart F was created precisely because CFCs are not passed through. The CFC was a separate legal entity that the U.S., as per treaties, was prohibited from taxing except U.S. source income. So what do we mean by here, John? So that a CFC.
Okay, so there, one of the there's a statement in the discussion. And by the way, this is not a personal. There's nothing personal against the participants in this discussion. Okay, it's just an example of the tremendous confusion that exists. But a pass through is where, it'd be like a partnership or something where, basically, so the partnership earns the income, but the shareholders are taxed on it. It's just automatic, right? I mean, you don't need a separate provision to do this. In this particular case, okay, the control of foreign corporations is a separate issue. It's clearly not a pass through. I mean, there are elections that can be possibly made in certain places, but that aside. Sure. Not a pass-through, it's a separate entity. And this is the whole reason why the Subpart F rules were created. If it were already a pass-through, you wouldn't need to create Subpart F, would you?
Oh.
Okay.
Right.
Now you see, yeah. I know it's too simple for the average mind.
Oh my God, that's what you meant. Oh my God, right.
But you see, again, the use of language like pass-through is a way of sort of reinforcing, hey, this is just current income.
Yeah.
Right? You see what I'm saying? God. It's just current income, and it's not. So, I mean, that's just, that it's not a hugely material thing. If CFCs were
pass-through entities, you would not need Subpart F.
Exactly.
Oh my God. All right. So now you have this number 2, but it's actually number 3. So use your imagination, folks. Lower courts agreed that the U.S. transition tax was retroactive taxation. Retroactivity is what distinguishes this tax from other examples of what are real-time income attribution. More can be decided on the basis that retroactivity alone, leaving all other fake income intact. So that's where we see, they're trying to hide the fact that it's retroactive by claiming it's deferred. But
that is my impression of this, Anthony. That is my impression, right? Because you call something deferred income. And by the way, there's one brief. There's at least one. I think it's from the Tax Law Center or something that actually their argument is based on this. Okay, that it was just deferred income. Right. And this is absolutely incorrect. Absolutely incorrect. OK, they can call it anything they want, but that doesn't change the basic character of it. It's real simple. Like a 5-year-old in a sandbox could understand this. Prior to the TCJA, active income was not taxable under Subpart F. Poof. They signed it into law on the date of, and created that. It's obviously not deferred income. I mean, this is a fantasy they have. And you go back to, I can't remember the name of this, but I sent you a tweet on it. A tremendous article written by a University of Michigan graduate student where he goes back to Stanley Surrey's original papers and traces the actual history of Subpart F. And there's two things that come out of that. Two things that come out of that, okay? The first thing that comes out of it, and this is really significant. Yeah, here it is right here. First thing that comes out of it that's really, really significant is that nobody even had individual shareholders in mind when this stuff was created.
Yeah, that's right.
Right? So we go from the multinational thing to the pensions of Canadians being confiscated. That's where we go with this, right? And the second thing that is absolutely 100% clear, it's no way negotiable, okay, is that when Subpart F was enacted, when they finally decided what it should be, the decision was that it was certain kinds of passive income and I suppose other kinds that were going to be attributed to shareholders in real time, not retroactively, in real time. The key point is active business income was specifically excluded, meaning there was specifically absolutely no law whatsoever that this was to be taxable through the Subpart F regime. And there's also evidence in that paper that what they mean by the word deferral is not that it's existing income that's deferred, but here's what they mean if you read the paper, that it's taxed when it's distributed as a dividend in real time. That's the definition of deferral. And now if you look at these people, they say, well, this is deferred income. Well, that should mean that it shouldn't be taxable until it's actually distributed, right?
Right. By definition, then that's right. Call it deferred income. Now I want to go over to Keith here. I know he's got to step off here because, as I'm going through this and it's like, I realize it's like, so Keith.
Yes.
So here's my question for you. I'm going through this and I'm kind of looking at what the opposition is saying. And to me, it's like this. They're just throwing up a bunch of international tax terms.
Right.
Like it's a word salad. Because have you been able to follow any of the opposition's arguments? That's my question. As they're sort of going on, claiming what this is and what this isn't. Are you able to follow along as our resident layperson with what they're claiming?
No, I mean, to be honest with you, I mean, I kind of consider myself a smart guy, but it's very hard it's very hard to follow along. I think where my frustration lies is, and I know you guys don't have the answer, but why is the individual consistently being ignored? And the ruinous effect of this, I don't understand why the individual is being ignored. It makes no sense to me.
I don't think they are being ignored. They're being expressly targeted.
Well,
ignoring would be an improvement.
Well, that's true. I should probably rephrase that. Why is the individual not being addressed vis-a-vis the ruinous aspect of the transition tax? Why?
Because they don't want to admit to what they're doing. That's what it is. They don't want to have accountability.
Because the individual doesn't matter.
Doesn't matter. Right. There you go.
The individual doesn't matter. It's just like everything,
I mean,
it's a metaphor for American politics.
Yeah, it doesn't matter. Shut up and pay your stupid taxes, or go to. That's what it's about.
No, it's not even that. It's not even that. Shut up. Don't participate in the discussion, and then we'll deal with you if at all later. That's it.
And
okay.
we see, and it's in that, and I really see how obvious it is that they're using the complexity of international taxation, complexity of tax code, to completely obfuscate what's going on. To completely obfuscate what's going on.
And to confuse people. And to confuse people. Yeah.
And to confuse the court. To confuse
and to keep them out of the discussion. Not to be, to keep them. The discussion. You can't understand what they're saying.
Yeah. And that is
the discussion being monopolized by tax academics that, clearly never saw a retroactive tax or fake income they didn't like.
That's what I don't understand. Why is so much emphasis on these tax academics? Because they don't deal with the reality on the ground. Nobody talks about the people. I consult with the people who deal with this every day. It just doesn't make sense.
That's another topic.
I know. If I was master of the universe, it would be different.
Keith,
yes.
Think Seat and the other amicus brief with Suzanne's in it. The individuals. These are the only instances of discussion of the harm of individuals anywhere. Although, and this is extremely significant, is that there are tax academics who have written articles and tax notes, get this, who are claiming that it's the fault of the individuals if they were subjected to the transition tax. I kid you not.
You're kidding.
Here's their argument, which is so indescribably offensive. Here's their argument.
They were supposed to be clairvoyant?
No. Well, yes and no.
In the U.S., why overseas? You should have been clairvoyant to know not to be overseas, you traitor. You should have been in the United States. That's where you should have been.
Well, it would include that. It would include that, okay? But here's what their argument is. They say, well, in the transition tax, if, all you had to do was transfer your shares in your foreign corporation to a U.S. corporation and declare it as an S corp, that's all you had to do. But I mean, first of all, that assumes anybody could possibly know anything about this. But secondly, on its face, it's a completely, absolutely idiotic statement. Okay, for two reasons. One, you think for a minute that the government of Canada, the tax authorities, are going to let you transfer your shares with a built-in capital gain in a corporation outside the country and not pay a Canadian tax? What are you, foolish? Yeah. Okay, it's another one of these. Well, only the United States has taxation, right? But the second reason it's ridiculous is because the United States is not the only country with CFC rules. All right. So somebody's living in France, which does have CFC rules. I don't know what they are exactly, but I know they have them, or Canada or Germany. All these countries have CFC rules. You transfer your shares to a U.S. corporation. That's a foreign corporation from their point of view. I mean, the stuff that comes out of these people's mouths and pens is just sheer fantasy.
You know what, John? I just want to take this time right now to thank you for helping me see, through and express, how full of it they are, how full of it all these tax academics are. And, what they do is they go and support each other's lies. Like, oh yeah, well, so-and-so said this. Oh yeah. So it's just an insider's club of lies. That's what it is. Lies just to steal money from people who don't have a lobby. That's what it is. And
it's an insider club of lack of awareness and no incentive to become aware.
Exactly.
Is what it is.
There you go. Yeah.
To lie, you have to actually understand that what you're saying is false, and I don't think they do.
You know what? Fair point, John. I actually don't think they understand. You're right. I actually don't think.
And the problem is with this lie with the tax academics is the journalists perpetuate the lie.
Yeah.
They just rely on them solely for their quote unquote expertise.
And they can't see the fact that these academics, what's their incentive? They don't think that, these academics are calling it like it is because, they're a professor, therefore they're totally unbiased. That's kind of the problem that I have. Like, no, a professor has a viewpoint, and a professor is an individual with their own wants and needs, and a need for security, a need for all the things that everybody else wants, and they're looking for the same things, and they can have the same bias. And so they have their own turf. Let's move on. I want to move on to tweet number 4. This is fantastic, John. That use of the word offshore is really offensive. It creates a suggestion that U.S. corps were carrying on business outside the USA to avoid U.S. tax, which is absolutely idiotic. Surprise, they carry out business outside the USA to earn profits, right? I mean, that's the problem that you have with the tax academics in the tax code itself. This is not, Anthony, let's stop beating up on the tax academics, okay? It's far worse than that, okay? I mean, it's the whole, sort of treasury, people. It's the whole group of people, right, who see the world through such an incredibly U.S.-centric lens. And also, through a presumption that anything everybody does is somehow to avoid taxes, that, they can't understand that there is a world out there. And, these U.S. multinationals are, trying to get their share of the business, right? I mean, there may be some people who create to use their word, offshore corporations, but I doubt there's very many, okay? The vast majority of this is just trying to run their businesses. Exactly. People are trying to live.
And they shouldn't be using words like offshore,
right? And here,
which is so pejorative, right?
And here's number 5, and this is something you not mentioned. Well, they were upset, right? They were upset, like, well, all these multinational corporations are paying less taxes overseas. Oh my God! Well, why is that? Well, the reason why is because the United States had the highest corporate tax rate in the world, I think, before 2017. So they were offended because other corporations weren't paying the highest rate of tax in the world, and then to lower the U.S. tax rate to 21%, the offset. Right? This is how are we going to afford this tax cut to the corporations? Okay, well, what we'll do is we'll tax retroactively the earnings and profits of corporations in which Americans are shareholders, and distributions that they never received. So I think that's kind of something your idea is like, well, going offshore is tax avoidance. Because, well, I guess so, because U.S. tax corporate was the highest in the world. John, what would you add to that? Anything to add to that?
You know, like what I've come to see is that their view of this is just a total fantasy, right? It's like a fairy tale. You know, you could make it, you know, you could put a little cartoon. There once was a corporation and it opened its eyes and saw there was a market outside the United States. And I thought, oh my God, there are German and French and Chinese companies. Why don't we join them and make some money? I mean, this is just completely beyond these people. The problem with this is that it has reached the point in the United States where, you know, the assumption is that anything anybody does ever is somehow to avoid tax.
All it is, because look, tax is so onerous and awful. Of course, everybody's going to be looking to do it. So maybe they implicitly know that it's a little bit that it is something you would want to avoid. Number 6.
Well, the other thing about this, Anthony, I mean, you know, the sort of thought that, well, corporations should pay our high 35% tax rate. What, are they out of their minds? I mean, you know. Is there something special about paying tax in the United States that's really paying tax, but you pay tax to another country it's not somehow?
That's real tax. They have the fake tax, right?
I mean, this is real tax. You pay it to the United States. Pay it somewhere else. Well, it's not real tax.
So number 6, what's really offensive is analyzing U.S. transition tax only in the context of CFCs where the shareholder is a multinational corporation. There are more individuals who are direct shareholders of CFCs, but they are not mentioned at all. Why are individual shareholders different? So what you're talking about here is because, and I think this might be tied together with the your next one, number 7, and these might be tied together. So let me just corporation shareholders of CFCs receive all benefits of the U.S. transition tax rate reduced to 21%, plus IRC 248A dividends receive deduction. Individual shareholders receive none of these benefits and all of the burdens. The mores are individual shareholders, which is ignored. And I'll continue with number 8. More on individuals. There is no mention of Americans abroad because of U.S. citizen taxation who are treated as U.S. shareholders of CFCs, which are not foreign to them and have tax residency in other countries. Their CFCs were really their pensions, many of which were confiscated. So John, this is the craziness of it, because if you listen to all of the people rallying around the proponents of the transition tax, they're saying, well, this transition tax was a massive giveaway to large corporations. And well, we got to make sure it sticks here. Otherwise, we'll still have this massive giveaway to corporations. And the point is just the giveaway already happened, folks. It happened in 2017. They didn't have to do this. Is this correct, John? Specifically exempted from having to pay the transition tax.
I didn't quite catch the last part of what you said, but the point I'm trying to make here is simply this, okay? It's fascinating, you know, this whole mortgage has been going on for, you know, some time now. And what's really fascinating is there's no multinational that's had any objection to this at all, at least publicly.
Right.
There are no multinationals, you know, that are filing amicus briefs. And the reason is, you know, very, very simple. They got a very sweet deal here, an incredibly sweet deal, because what they got was, you know, we're going to cut your tax rate significantly from 35% to 21%. That's pretty damn good. And in return, okay, we're going to give you a partial benefit on foreign income. Okay, it's not territorial. Okay, but you know, you've got a somewhat lower tax on that. But the main thing they got was the lower tax rate going forward. So in other words, the corporations got clear benefits from this. Maybe not as good as they wanted, Okay, but they got clear benefits. The other thing is they were able to pay all the tax if they wanted over an 8-year period, with it heavily loaded in years 7 and 8. So, that would also mitigate the amount that they were going to pay. But the key point is, other than the 8-year thing, individuals got absolutely none of this stuff. Absolutely none of it. Okay, they never got any lower tax rate. They never got, any dividends that they receive are still fully taxable. Et cetera, et cetera.
It's in the proponents of the transition tax have it exactly backwards. They have it exactly backwards, and their class warfare claims are completely backwards. That no, the large multinational corporations, of which are the big enemy, right? They did okay, and the small individual who is supposed to be the person they care about. No, they got the shaft, but that's okay because we see who they're really after. It's just an ever-growing government, with more and more power.
Anthony, I think the point here is that whether you call it the transition tax, the MRT, or whatever, it's really 3 different taxes, okay? Or it's 4 different taxes. All right. First of all, it's just the straight multinational, with a U.S. C corp as the shareholder, right? Now, notice that in that case, sure, it's an issue for the company, but the individual shareholders of the C corp don't have to deal with this directly, right? Now, for that group, I think this was arguably a benefit, right, because of the lower tax rate. Yes. Okay. Now, the second group would be the Chapter S shareholders who essentially were able to get through this without any problems at all because of a specific exemption in Section 965, and these were the ones who had some awareness of this, and of course there's the the S corp lobby. The third group would be the people like the Moores who, this clearly wasn't their pension or anything, right? It was just sort of an investment that they were involved in. Clearly, for people like that, and I know some individuals who are U.S. residents who were impacted by this, it was unpleasant, okay, but it was, it was just a, part of their investments. It wasn't like, it was their sole pension or something like that. And then the fourth group was Americans abroad, who, now, by the way, here's another thing that's incredibly offensive, right? I see these suggestions occasionally on Twitter that, it's their own fault, these Americans abroad, because they didn't, make a check the box election or something. Leaving aside the pure, absolute ignorance of this statement, I would make the point that whether you can make a check the box election depends on what the Treasury regulations say from 1996. And if you look at Canada, for example, those are per se corporations. There is no possibility, right, of making a check the box election. So really in 1996, through the entity classification rules, those rules locked in Canadian corporations effectively to the transition tax, right? But the thing is, we're talking about this on a level that, almost nobody understands, okay? Anyway, so the fourth group, right, would be the Americans abroad who, their CFC is their livelihood, it's their pension, etc. And this was basically, in many cases, just confiscated, right? So, and then I would add to this, okay, that the modus operandi, right, of the people supporting the Ninth Circuit, right, is, for God's sake, let's not talk about the individuals, right? Let's keep this on the level of, the multinationals. Oh my God, if this is struck down somehow, then, then they're entitled to a refund or something. I don't know if that's necessarily true or not, but the point is the individuals should be separated from the multinationals in this discussion.
Yeah, and number 9, sheet now an ARRO file amicus briefs and more for the transition tax appeal. The brief explains in some detail how the MRT affected Americans abroad differently. The brief should be entitled "How Citizenship Taxation Really Works." I'm going to put the link to this tweet storm in the super chat, folks, so you can go yourself and follow these links to read the briefs. And hey, get in there. Why are you not doing that? Hold on a second. I messed that up. I just messed that up. All right, I'll set it in a second here. I want to move on to number 10. A second brief describing experiences of individual shareholders of CFCs, including the experience of Now member Susan Herman. She read that to say exactly how Americans abroad are treated so horribly. This is a great summary here. The U.S. transition tax was one, the retroactive creation of new, not deferred income. Two, based on income previously earned by a CFC, but not taxable to you, a shareholder. Three, never received by shareholder. Four, but deemed to have been received by shareholder in current year. That's a fantastic summary. That's a fantastic summary.
Yeah, I think that's probably, yeah, I've been grappling with this for a long time, and that I think pretty much sums it up, right?
Yeah, that sums it up. This, and this is, and I think this is, this is, I think, the core argument, and I think this defeats all the, and everything else they're throwing up there is just to distract you, so you don't talk about it. But they cannot get it. Is it retroactive of new income? Yes, it's not deferred. Stop that. It's not deferred. Nope. Based on income previously earned by a CFC, but not taxable to you, a shareholder. 100% true. Never received by the shareholder. 100% true. But deemed to have been received by shareholder in current year. I mean, you're making it up. That word deemed just means, yeah, we're going to make it up because we can. That's all it means. Number 12. More is not about a wealth tax, which is true.
Yeah, let me pause here, okay?
Oh, yeah, sure.
Yeah, 12 is to do two things here, Anthony. Okay, the first is that so much of this, you know, in politics, there's a saying, define or be defined. And the reason that, you know, I look at that CNBC interview, my assessment of it is that, you know, I think everybody's honestly doing the best they can. But it's very, very clear to me, okay, that what this case is about has been slowly modified and redefined, right? By, you know, the government, by the tax academics, you know, this sort of stuff, right? So I think the first thing I want to do is review what this is not about, okay? You know, a lot of the tax academics are in hysterics, claiming that this is somehow trying to forestall a wealth tax. No. A wealth tax is a straight tax on wealth. It's an entirely different issue. Perhaps a tax on deemed capital gains, you know, that might be caught by this, but not a wealth tax. So that, I think, is an extremely disingenuous statement. But then again, what would you expect from
well, and the reason why, and this is the reason why I say it's not a wealth tax, because the Moors didn't have it. It didn't belong to them, so it's not a wealth tax. It's not their wealth. The corporation's equity, their earnings and profits are not the Moors. It's not part of their balance sheet. What that isn't theirs. If they went to take that money, they would be likely arrested for embezzlement. It's not their money. They don't have any right to it. So you really can't call it a wealth tax. That's where it's like, it's not their wealth. It doesn't belong to them. So so it's about
not about a wealth tax. It's not about deferred income, and this is critical, right? Because this is the great sleight of hand that redefines the issue, right? Oh, it's income, it's deferred income. You know, first of all, that begs the question of whether it's income to begin with, but secondly, it removes the emphasis from the retroactivity. Okay, next. It's not about multinationals. Sure, multinationals might be affected, but hey, buddy, the Moors, as far as I can tell, are living, breathing individuals. Okay? You know, which, you know, they don't want to talk about either. What this case is about is it's a current tax on retroactively created income attributed to an individual that the individual never received. Now I want to add another point here, okay? That at least in the case of the Moors, they could not compel receipt of it either, okay? As only, you know, a 10 or 11% shareholder. They could not even have compelled receipt of it. So this is absolute nonsense.
Right.
Now,
nothing they could do.
Let's pause here for a minute. So what's interesting to me at this point, as you know, we go to the court hearing, is, you know, when I look at that CNBC interview, it's really clear to me that there were three people who in the discussion didn't understand the issue at all. The first was the interviewer, who was clearly confused.
Mm-hmm.
The second was the retired politician,
Senator Breaux.
And the third, regrettably, was the guy at Tax Foundation, or whatever it is. Okay? I mean, they were just going from talking, deferred income, offshore,
wealth tax,
all this type of crap, that is clearly, I think, wrong. So we're left with a situation where, I don't know exactly how to characterize it, but I would really be surprised, given this context, if even the court is going to be able to understand this. And
well, I'm going to,
and this is why I included in my final tweet. Here's the last paragraph of an article written by Professor Michael Gratz, November 14th, in Tax Notes, where he ends with this. Referring to the Supreme Court, the justices and their clerks have a large stack of briefs to read, understand, and evaluate between now and December 5th, when the oral argument is scheduled, and more. Based on grading exams at Yale and Columbia law schools for many years, I was always disappointed how poorly I had taught the course because of what the exams revealed about the depth of the students' knowledge. My successors may be doing better than I did in that regard, but I would be surprised if there are many tax experts among the justices and clerks of the Supreme Court now. I hope this does not cause major problems for the income tax, right? In other words, with all this background stuff going on, it'll be fascinating to hear the arguments. But I mean, I don't know if anybody's going to understand the issues.
Well, his last sentence is what I laughed at. I hope this does not cause major problems for the income tax. Well, I think we have those major problems here. So I think that the ignorance and lack of knowledge and lack of curiosity. And I can tell you this myself from my own experience when I went to law school at Quinnipiac. I didn't go to Yale. I went down the street to Quinnipiac. And what they did before other law schools did is they forced all of us to take federal income taxation. Second year was something that we were forced to take. No one wanted to take it, including me. Now I happened to take it with my dad going at nights. He was going to law school at night, so we were able to go together. And so I went at night. So I had actually a pretty good time in the class, and Professor Ferrari was awesome. But what I could tell you this is that your typical law student can't stand tax, wants nothing to do with it, wants to get it over with as quick as they are. It's just this horrible thing. No one really likes it, and no one truly understands it. And you wonder, okay, what do I have to do to just get my requirement done? Okay, good. That's it. I'm done. I'm not going to look into it anymore. So that the fact is that we have a tax code whose complexity outstrips the ability of the aptitudes of people who are supposed to understand it, know it, argue for it one way or another. It just goes beyond what any typical lawyer wants to do. And hey, look, and when I was in law school, I wanted to work on real constitutional issues, which cracks me up. I wanted to be a constitutional lawyer. That's what I was going to be. And then I'm kind of laughing, John, as we've kind of gone full circle, that I actually did. I actually did become a constitutional lawyer, John, because I practiced U.S. taxation. And as we found out, the real Constitution of the United States is the tax code, or whatever the courts say it is. So I think that's really the biggest problem that we have. And that's really what we should be looking for on oral argument on Tuesday, is how well does anyone really understand the issues? And that's what's going to be revealing that now maybe because we've seen the attacks go on against Justice Alito and Justice Thomas, against those two, maybe they know it the best. Who knows? Well, that's what I'm curious to find out, what I'm looking for. So we're going to have an incredible podcast on Tuesday as we cover the live stream. That's what I'm looking forward to hearing. Is there anyone on there who's actually going to understand the issues? And it's so hard because, again, the tax code outstrips. It takes up so much. It's so expansive. No one could really understand it, including Supreme Court justices.
What it's done, Anthony, is the complexity of this is such that people look to the tax academics to explain what's going on. Okay, nobody can understand it. And look, I'm not saying that I think they're being dishonest or malicious or anything, but I do not I think that they're wrong, okay, in many of the, things they're saying, and they're approaching this, their total disregard of individuals, their inability, or, perhaps deliberate, to see how, how taxes in other countries affect this thing. This latest, which is really offensive, some of these tax academics trying to blame the individual. Imagine blaming a U.S. citizen abroad for not creating a C corp, an S corp. I mean, how ignorant is that? I mean, but this is what's going on, and we'll have to see. We'll have to see. I mean, I think that what could happen here is, I mean, it's extraordinary, because I think the most likely scenario to unfold on Tuesday is not a single participant with a really great understanding of what's going on. From sort of, a technical point of view, I think that they're all going to be in agreement that, yeah, they wanted to take this money from the corporations. But I mean, I think that that's likely where it's going to end. And I will be very interested, in light of the seat brief and the brief of the individuals, I call the Suzanne Herman brief. I will be very interested to see if there's any acknowledgement at all of Americans abroad. Now, in the FBAR case, in the Bittner case, Justices Gorsuch and Ketanji Brown Jackson, whatever, did acknowledge individuals. So we'll have to see what happens on this. But anyway, I mean,
so hopefully, Suzanne is happy here to potentially play a role in blowing up the U.S. tax code, and I think that's what will give me good feelings if I start seeing Suzanne's arguments pop up in oral argument, then that would be a good role. But that Melvin has indicated that the SCOTUS didn't understand that a $2 million penalty for a non-wolf to report something is an excessive fine. So he has very little hope that they're going to understand more about the complicated tax more case. Melvin, here's why I have hope. I want to tell you why I have hope. Because of the attacks. Because the attacks against Justice Thomas and Justice Scalia, and Justice Scalia. I can't say it now. I'm putting Alito. Thank you. Those attacks make me think something else is going on. Hopefully, I could be disappointed, and probably will be, as the tax code is so complicated. It is outside the realm of the Supreme Court to actually understand it and rule it on a way that makes logical sense. So
well, they can't understand the limited time they have. This is the problem. Okay. I mean, they're obviously, intelligent people with intelligent clerks. I mean, if you gave them, a few months, to focus on this and this only, then I think it would be reasonable for them to understand this. But what I worry about is, that they're going to be swayed. They're going to defer to the academic community, right, on what's going on here, and that's not good. If that happens, we'll have to see. I mean,
they have a lot of other cases.
It is a horrible thing. Well, we've talked about the fact that this is the single most important case the Supreme Court has ever heard and possibly ever will, because basically, look, I mean, we've talked about, I said before that if they can define this as income, they can define anything as income. But just imagine this for a minute, right? This whole thing is largely hinging on this. Well, this is just deferred income. If they can call this deferred income, they could look around the world and point at anything and say, "Oh, look, it's deferred income. Let's tax it." I mean, there's no end to this.
Yeah,
there's no end to it.
And that is, and again, it's not a wealth tax because it's just a confiscation tax. It's just, here.
Well, it's not a wealth
tax.
Well,
it's not even it's not even confiscation because you don't even have the thing.
Well, it is confiscation. Well, no, it's a confiscation
of other things, but it's not confiscation thing. Yeah.
All right. Should we do the poem? It was the night before.
All right. Yeah. Let me. All right. I'll do this. So
we're going to need some help from listeners to finish this poem off. But I thought this would be. 'Twas the night before more. 'Twas the night before more.
Do you want me? I'll do the honors.
Can you put it on the screen?
I don't think so. Not sure if I can. I could read it to her.
The most important part of our podcast today, Anthony.
This is the most important part. Oh, geez. Okay. Let me see here if I can get this up here.
We can open with it on Tuesday as well.
All right, hold on a second. All right, here we go. I don't want, you know what? I don't want to let anybody down here. Let me see if I can get this here. Let me see if I can start a new screen share here. If I get this here. And, ooh, is that it? Nope. Let's see if I can find it. Is this it? All right. Hopefully I'm getting the right thing. Do you see it? Do I have it, John?
Let's see here.
I do have it. All right, there it is. All
right. Yeah. Okay, hold on. Let me just pull it up as well here. Okay. So we're going to need some help from listeners to finish this off, but I thought that this was perfect for the time of year and what's going on. 'Twas the night before more poem. Okay, you want to read it or shall I read it?
I'll do it. I have the fancy microphone here. I think that
okay, go for it.
That's a responsibility. 'Twas the night before more. 'Twas the night before more when all through the court not a justice was stirring, not even a clerk. The issues were hung in the briefs with care, in the hopes that the justices soon would be there. The tax profs were nestled all snug in their beds, while visions of fake income danced in their heads. And Kathleen and Kerchief and Charles and Cap had just settled their brains for a retroactive tax. When out in the lawn there arose such a clatter, I sprang from the bed to see what was the matter. Away to the window I flew like a flash, tore open the shutters and threw up the sash. The moon on the breast of the new fallen snow gave the luster of midday to the Supreme Court below. When what to do my wondering eyes should appear, but Chief Justice Roberts with those 8 he held so dear. With little old driver so lively and quick, Justice Roberts was just like St. Nick, more rapid than eagles, his coursers they came, and he whistled and shouted, called them by name. Now Clarence, now Neil, now Katanji and Sam, oh Amy and Elena, and Sonia and Brett. To your seats at the court, away from the wall. Now dash away, dash away, dash away from it all. And that could be the outcome there, that the Supreme Court just doesn't quite understand the issues and dashes away from it. But we shall see. So be sure to join us here live Tuesday, December 5th. The big game is on at 9:30 a.m. as we pregame it. We're going to be going over oral argument again. And John and I are convinced that this is the most important not just tax court decision, most important Supreme Court decision of all time, because it will radically, if it is upheld, it radically changes the relationship between American and its government. And it's all over. I mean, it's awful. If it is repealed, held back, well, then maybe there's some hope for us, but we shall see. So I want to thank John so much, and I want to thank Keith for joining us earlier. He had to hop off. We had I want to thank you all for a great show, and we look forward to seeing you. And please be sure to share our live stream with everybody you know, because it is an incredibly important issue for Americans overseas and anyone really with income overseas, and actually any American. Because what they're doing is they're just picking on people who don't have a big political lobby and hammering them. And so guess what? You allow this to happen, everyone's going to be next. So that is what we are up to. And if it is held, as Melvin just says, one more reason to renounce, because where do all roads lead to?
Anthony, listen, on the issue of renunciation, for anybody listening to this, I saw, as you know, I don't write stuff on, on these videos or anything, but I saw some comments on the last video. I think it may have been Melvin, actually, who believes or understands that 5 years of tax is a requirement to renounce. That is not the case. You can renounce with or without tax compliance. It's just that if you renounce without the 5 years, then you become a covered expatriate. Okay. To be clear on that. It's not like, when you go in to renounce, they're going to say, well, can you prove you're tax compliant or something? Either way, you can renounce. It's just that renunciation without the 5 years has a tax impact that you're a covered expatriate, right?
All right. Yeah.
Yep.
Right. Melvin
All
roads
roads lead to renunciation.
There we go. All right. Well, folks, thanks again for joining us today. Really appreciate all the feedback and everyone, the lively discussion that we have. Incredible. We could see the problem we have. We have something so complicated that we're trying to explain, and it's so complicated that the opposition is out there not to explain it, so that the Supreme Court is led down the wrong road. With that, this is Anthony Parent for Keith Redmond. Thank you, Keith, for joining us. And John Richardson, thanks so much for watching. We look forward to seeing you on Tuesday.